All right, thank you, counsel. Thank you both. All right, the court will call Mark Eaton versus Sherry BYERS. Morning.
Good morning, sir. If it please the court, are you ready for me to proceed?
You may, sir. Go ahead.
Your Honor, my name is Michael Hatfield. I'm here. My partner, Mr. James Baxley, is behind me. I'll introduce him to the court at this time. We're here on, and it's been my privilege to represent Mr. Mark Eaton. I know that you have questions for me, but if I could have just one moment. The real issue behind the issues we've appealed relates to the problems that I have as a lawyer. The value of my services to each client is whether I'm accurate when I give them legal advice from the statute and what we anticipate these facts to be. And initially, I interview the client. I read over the statute for them to understand what we're dealing with. We give him advice related to the client's rights or her, and we give them a lecture of some length on due process of law and what he may expect as to what will be the processes.
I'm sorry to interrupt you, but you've just totally lost me. I thought the issue on appeal was whether the trial judge based his ruling on substantial competent evidence.
It is, sir.
Am I missing the issue? Oh, okay.
And the only reason I mention that, Judge Torpy, is because we did exactly that in this case, and I rendered an opinion to this client. And we went to trial, and the facts are exactly what we anticipated them to be, and what we expected is that the trial court would apply those facts to the law related to dating violence. And we were quite astonished to have the injunction entered, and our complaint is simply this. And I know that this court has, and each judge has reviewed facts of this case and the memorandum, but what in the brief, there is no opposing.
So you want us to rule as a matter of law that there cannot be an injunction against dating violence if after the violence occurred, neither party has any intent to date again.
Absolutely.
That's the holding of the case.
That should be the holding in this case, and there should be an opinion upon which we can then advise our client.
Even if the party that made the threat said that if you ever leave me, I'm going to kill you.
Well, Your Honor, we don't. If those facts were in this case, but we do not.
Well, we're talking about a rule of law now. That's what I'd like to focus on. What is the rule of law that you advocate?
The rule. First of all, what I seek as a rule of law is the rules of construction of the statute that are construed in favor of my client in Chapter 775, I believe 021 of Florida statutes, saying that my client is entitled to anything in this statute to be construed in his favor.
Well, wait.
Yes, sir.
You read the statute to your client, you said.
Yes, sir.
Part of the statute, 784-046-1D, says dating violence means violence between individuals who have or have had a continuing and significant relationship of a romantic or intimate nature, correct? And
we stipulated, Your Honor, that relationship had existed up until, I believe, April the 13th, which is the date of this incident.
Well, they had been dating for 8 months. They had an intimate relationship that was admitted. There was an allegation of violence. Each party alleged the other did some violent act. There was indication from photographs that there was a basis to support the petition's allegation, a circle, which she says was a gun barrel placed against her head. The judge heard all of that, and the rule is if there was competent substantial evidence, the judge can enter the injunction. Is that not correct?
That is correct, and we cited these cases, Ravitch and the other case that says that, but it is our position very clearly, Your Honor, from the totality of the circumstances and testimony in this case, that I don't know where this judge could have ever gotten that idea.
How about from the witnesses, the victim's testimony, that she was assaulted, threatened with a handgun, left in a hurry and walked home and reported it, and a petition was issued, a hearing was held, and the judge believed the victim.
If you believe that, Your Honor, then you must also believe that she will never date this person again. If she is not going to date this person ever again in her life, and he swears under oath as well that he will never date her again, then what you have is no possible chance of another act of dating violence, because there has to be a reasonable belief in her heart that she is going to go out again with a man that she says held a gun to her head.
The judge was concerned for a number of reasons, including the proximity to which they live one to the other. And the law is clear that you don't have to have violence or the beginning of the relationship anew for the injunction to be valid.
I understand that, Your Honor, but the plain context of the law is that there must be the reasonable expectation in her that she is going to date him again and again reestablish a relationship. And one of the portions of our appeal go to the fact that the extent of the injunction, which seems to be a repeat violence injunction, there is no allegation of any prior violence in this relationship.
Well, didn't she say he broke the window out of her car? They had an off and on again relationship, and that he had been sent to anger management classes? Isn't that the testimony that was before the trial court?
That related to an incident that was not a domestic violence issue at all, for which I do believe the charges against him were dismissed.
But the judge was aware of this contentious relationship and acts or allegations of violence. Is that not correct?
It's not in this record sufficiently, I'm assuming, but I want to make it clear that incident had nothing to do with a man and woman or dating relationship or anything to do with that.
It's part of the record on appeal.
Well, it's in the thing as he went to anger management, yes. And
it's in there that he broke her window out. Is that not correct?
If it's there, it is there, John, or I have to deal with that. It is still my contention, sir, that if the statute mandates that they be dating again, you not only have to date again.
Where in the world do you find that in the statute?
Well, ma'am, I've cited.
I mean, I'm looking at the statute. The statute defines dating violence as violence between individuals who have had a relationship. These are two individuals who have had a relationship. That's what dating violence is.
And the
statute says that if the court has reason to believe that he or she is in imminent danger of becoming a victim of another act of dating violence, i.e. violence between individuals who have had a intimate relationship, then the court is entitled to enter the injunction. I'm baffled by your contention that they have to start dating again. That's not what the statute says.
Ma'am, not only do I think they have to start dating again because the statute says she has to be in fear of another act of dating violence.
But dating violence doesn't mean they have to be dating. Dating violence is defined as an act of violence between two individuals who have had an intimate relationship. Those are two entirely different things.
Please forgive me, Judge Griffin. I'm ready to comment now. And this has to, but this dating relationship must exist for the preceding 6 months. And if they are, this is what got us about the 1-year injunction. You would think, well, gosh, that's not much. Under the circumstances of this case, however, she admits she pulls a knife on this guy in his own home, and you wonder, well, is she entitled to a Peterson? Are we entitled to even a Peterson hearing on that? He's in his own home. He has no duty to retreat. She is coming down the hallway at him with a knife.
Well, it's a credibility issue. The judge believed her and did not believe him.
Well, then again, Your Honor, I don't want to beg this question. If he believed her and not him, then he believes that they will never date again.
What sense would it make to issue an injunction if there's been violence, they start dating again, then stop? At what point would the injunction have any credibility or would be logical?
I think that it wouldn't make any sense, and that's what's been attempted. And I think that the statute is flawed, Your Honor, and it precludes an attorney in my position giving legal advice to these people based on the plain statements in the statute.
Does the record show that you went back to have the restrictions amended or removed or to have the injunction ended? Is that in the record before us?
No, sir. We explained to the judge we thought that was inappropriate ruling, and he made it clear that we should appeal. And this is what we have done. And
sir, hold on a second.
I beg your pardon.
You didn't answer to my satisfaction, and probably not to Judge Griffin's satisfaction either, her question, which was really directed to the crux of your argument.
I'm sorry, I'm a little hard of hearing, Judge. Forgive me.
All right. Judge Griffin asked you about the definition of dating violence, and you know, dating violence is a term of art because it's a phrase that's defined in the statute, and you don't have to have an ongoing relationship in order to meet the definition of that statute.
Well,
I would like you to address Judge Griffin's question. If you have a retort to that, I'd like to hear what it is, because I think that's really, what I'm the most curious about.
Here's where I'm getting it, and I cited in my brief as 784.0461D is in Delta. Right. The definition of dating violence, and it has been accurately stated by Judge Griffin, and then it includes, number one, a dating relationship must have existed within the past 6 months. And if you are in fear that he's going to come and burn your house, that is not an issue of dating violence, Judge Griffin, I guess, and Judge Torpey is what I'm trying to say. If this statute, that would be an act of repeat violence, and her action would then be under repeat violence or something. That's not what we have here. What we have here is, and why I am here today, is the legislature needs to amend the statute or something, because the way this statute reads, and the only way that as an attorney I can interpret it, is to say that if they date again, take 6 months from April into October, if they're not dating from April 13th to October the 20th, then if they're going to get another dating violence injunction, they have to start dating again to meet the definition and date for 6 months. That's the statute. And I don't mean to be pantomime, but all I can do is read the statute and then look at 775.021 and then tell a man or a client or any client what their expectations are and reasonable expectations of an outcome, and take their money and go forward. And the value of those services is being accurate. And I've tried in my career to be as painfully accurate. And I know that I have been wrong on occasion. Perhaps I'm wrong on this occasion, but I believe that the greatest benefit to the bar could be a ruling from this court that makes it clear that we can rely on 775.021, that this statute is construed in favor of my client as you read it, and there is nowhere in this record that you can say this judge could have reasonably concluded that both of these people were misrepresenting that they would never see each other again. And that's my point. And I'll wait for your questions. We won't belabor it.
I don't have any other questions, but you got more time. It's your time, so you use it if you think you can use it, and not just be repeating yourself.
I'm hard. Yes, sir. I don't want to just go rambling. I think
did they have a dating relationship within the 6 months prior to the injunction?
I beg your pardon.
Did they have a dating relationship within the 6 months prior to the injunction?
They did, and we stipulated to it, Your Honor. We put forward as straightforward as we could come.
Okay.
They had that relationship. We conceded that relationship. It was not an issue in this case. The likelihood that how you can get that she could be reasonably believed that she would begin dating again, which is what this is all about by statute, is just simply not there. Then when you consider the sanctions that were imposed, I think the statute again is flawed, and I think they could revise that or refresh that and take care of it. It's a legislative matter, and not. But I think that if we have an opinion from this court, we have something to go on. When we took this case, I looked under dating violence, and there's nothing. And
is this case about the right to bear arms? Is that what he wants?
No, sir. It's about, and that's why I began the way I did, and I apologize if I misled you, but the bottom line is about, Mr. EATON is a small player, as usually will happen in the appellate court. I think the bar needs guidance as to whether these statutes mean what they say, and whether we can give accurate legal advice to the clients related to those statutes, and they rely upon them and put out their hard-earned money on a reasonable expectation. Quite candidly, I don't see how the judge reached back to these people who are going to meet the requirements of this statute. It's totally beyond me. I just can't. It doesn't. I think this judge was totally in error. I'll tell you what, if you were to ask me, well, Mr. Hatfield, what do you think the judge did? I think the judge did what I would do if I was not a judge. I would do something to keep these two people apart. And so he did it. Unfortunately, in this context of appellate law, where we are trying to rely on prior decisions, and we look mostly to the 5th District Court, where we appear, and we say, there's no way to crunch this into this statute. You have to gnaw off the corners of square things and try and put them in round holes. This statute is clear. The proof wasn't there. The lady had the burden of proof. To reach the decision that Judge Eddy has reached, you had to disbelieve her and him, and then come up with what might have happened, or what may happen in the future. And I quite candidly, I will tell you that I do not believe that is the function of the trial court. The trial court has to deal with what the sworn testimony is. And there's nothing that would indicate they would date. Again, all of the cards are stacked against these two would ever speak to each other again, much less date. I mean, who in the world would be stupid? Now, if it were true, which Mr. Eaton says is totally untrue, and the officer came and there was no gun, and he invites him into the house. If these were true and she was falling down drunk, but he's sober enough to ride a motorcycle all evening with her hanging around on the back, and she goes and pulls a knife on him in his own home, to answer your question, which I apologize and I'm finally reaching it, I believe that he's got a right to defend himself in his own home and stand his ground and not flee under the statute. And none of it's true, we didn't raise it, but how the judge found these facts that they would fit this statute just absolutely beyond me, and I apologize for my getting wrapped up in this thing, but I've given what I thought was excellent legal advice. We tried a case to elicit from the witnesses what we anticipated the facts would be. They turned out to be exactly what I thought they would be. Obviously, I've reached to my client for those facts, and the facts turned out to be identical to what he said, except for this business about the gun. But she admits she pulled a knife. She's intoxicated. She comes back down the hall, passes 2 exit doors. Where did he get this gun from when he came down the hall and sees her close to the bedroom door at the office in these photographs, where she could have walked out and gone home? Where did he get this gun? If you look down the photographs that were provided to the judge, it's a completely empty hall. There's no picture hanging there that you could hide a gun behind. Nothing that would indicate the presence of a gun. She had misrepresented facts to the court. We challenged her on it early in the case. We didn't beat up on her. Assuming he doesn't want to beat up on this girl or pull a gun on her, but the facts of this case are wrong. And I don't know. These cases, when you boil down, I brought a T-shirt over here. I don't mean to make little of the domestic violence law, but I want to show it to you because if you see a lot of these cases, my experience with domestic violence is on this T-shirt right here. And I bought a bunch of them because I think that's it. And this T-shirt says, I didn't say it was your fault. I said I was going to blame you. And that is, I look at these facts and I look at that T-shirt and I try hundreds of cases of these domestic violence issues, and there were no surprises in this case. The facts are this woman is intoxicated, arms herself with a knife in my client's home where she is a guest, apparently has every intention of returning to the bedroom and carving him up. She complains because she has a bump on her head where he took a knife away from her that she claims she dropped. She left. A week later, she wants an injunction. If she went to a state attorney, they said somebody has concluded that it's not a prosecutable case for sure, probably because of her lack of credibility, but I can't read this in, and it's not in the record. So I've done what I hate to do, is I've gone outside the record, and I apologize for that. But if you look at the record, which I have to do.
All right, sir, you're out of time. Thank you.
Thank you so much, John, for listening to me.